Well, welcome everybody. Thanks so much for joining this People Matter webinar today, which is on managing disability-related concerns. So this is actually 3 of 3 in this recent disability series. So hopefully you will have joined for the earlier 2 as well, because disabilities are a complicated area, as we all know, and we could probably talk about it all day. So we've already had a detailed look at what the definition of disability means and the duty to make reasonable adjustments. But Nick and I are going to focus today on managing disability-related concerns. And what that's going to look like, we'll come on to in just a second, but just a quick bit of housekeeping. So this is being recorded and you will get a recording available afterwards. Please do ask us questions in the Q&A box. It'd be really good if you could put your name in there. We won't attribute your name to the question when we get to the end. Nick and I are going to be talking for the half an hour slot, and then we'll try and pick up some questions at the end if we can. When you leave the webinar, there is a feedback form, which we'd really appreciate if you could fill that in as well, because it's always great to get your feedback. So just covering what we're going to do today, we're going to be looking at how these concerns, when you've got a disability, somebody with a disability, how that can impact on recruiting people, managing performance, managing sickness absence, and dealing with misconduct. So I'm going to hand over to Nick now for the first section on recruitment.
Thanks very much, Rebecca. I suppose the first section is in recruitment and what you should be doing to assist disabled employees and job applicants in the recruitment process. Well, there are a number of different things that you could be doing here. So ensuring that your processes attract a wide range of talent. That will mean having accessible job adverts, job requirements that are genuinely non-discriminatory and necessary, objective criteria. So not having criteria which relates to health unless that can be objectively justified, and other things such as including a diversity and inclusion statement, or specifically saying that you're happy to discuss reasonable adjustments. That will signal to candidates that you welcome a wide range of people applying for the role. The second one there is taking positive action to improve access for underrepresented groups. Positive action is different to positive discrimination, which is unlawful. Positive action needs to be carefully balanced and based on evidence. But I mean, what that may look like is so removing any barriers in your recruitment process. So actively encouraging applications from people with a disability, offering those who are disabled an interview if they meet the minimum criteria, for example, to allow them to showcase their skills and abilities. And then the third one there is making reasonable adjustments to the recruitment process itself. So take a long look at your recruitment process and consider whether there's anything that you could actually do or currently which places a candidate as at a disadvantage because of their health condition or disability, and look at, are there any adjustments that you could make? So could you adapt the application form process itself, adapt any selection exercises or tests, offer communication support, and then just generally sort of things around sort of interview rooms and making sure that they're accessible from a mobility perspective. So when can you ask health questions in the recruitment process? Well, pre-employment health questions are prohibited, subject to very limited exceptions. Those exceptions are there on the screen, but some of the main ones include where the question is necessary to establish if reasonable adjustments are required to the process, or where it's necessary to establish if the individual can carry out an intrinsic function of the job. And some of the other exceptions there on the board for you to read. You do have more freedom to ask questions post a job offer being made. However, as always, you should be careful not to discriminate and consider if any reasonable adjustments need to be made going forwards. So there was a recent Employment Appeal Tribunal case which actually showed the importance of following up inquiries about implementing adjustments to the recruitment process, and that was the case of Malone and ACOM. Mr. Malone had dyspraxia. He wanted to apply for a role at ACOM, but ACOM required their applicants to submit a short online application form and create an online profile. Mr. Malone emailed ACOM and asked if he could apply orally because of his disability. There were some email exchanges between ACOM and Mr. Milan, and ACOM insisted on him completing the online form, but let them know by email if he was struggling. Again, Mr. Milan said that he'd prefer to do it orally, but no one rang him. The EAT held that this was a failure to make reasonable adjustments. The recruitment process that ACOM adopted put Mr. Milan at a substantial disadvantage, and ACOM were required to make reasonable inquiries as to the extent of the difficulties he faced. I'm handing over to Rebecca on managing performance.
Thanks, Nick. Yes, let's have a look now how we manage performance when you've got somebody who has or may have a disability. There's a number of steps we really need to take in this situation. First and foremost, we really need to be meeting with the individual to understand why they're not meeting the performance standards that we expect, and to try and ascertain whether there are any health issues that could be impacting on that. Because if there are, we need to think carefully about whether we need to put in place some adjustments. We need to deal with things sensitively, and it's always best to get medical advice. We mustn't make assumptions. We really need to be thinking, can the employee actually meet the standards that are required? And we need to keep an open mind in this situation and keep careful records, because actions that follow, if you need to manage somebody's performance, can be unfavourable treatment arising in consequence of a disability, which is, of course, the Section 15 claim under the Equality Act. So just looking at a particular case on this, which is Linsky and Direct Line, this is actually a menopause case, and menopause cases are turning on their own facts. The caveat with this particular case is that it is an ET decision, and therefore it's not binding, but it is illustrative of how a tribunal might take a decision in this type of case. Well, Mrs. Linsky was a telesales consultant at Direct Line, previously been doing very well. She started to suffer from symptoms in the menopause, which she did tell Direct Line about, and they did make some adjustments for her, but they didn't go far enough. So when it transpired into an ET claim, she ended up resigning, and she brought a claim for a Section 15 claim and failure to make reasonable adjustments. And the ET found that they had discriminated against Mrs. Linsky because although they'd done some adjustments, they should have gone further. And they also took some extra steps against her. So they gave her an improvement required, which she couldn't meet. And that subsequently meant that she couldn't get a pay rise as well because of that improvement required rating. They also stopped paying her sick pay sooner than they needed to do so under her contractual entitlement to try and encourage her back to work. And that was found to be discriminatory. Now, as we know with Section 15 claims, if we have treated somebody unfavourably because of something arising in consequence of their disability, there is the option of the objective justification argument if we've got a legitimate aim and if it's a proportionate means of achieving that legitimate aim. But the ET were not convinced in this case. They thought there could have been less discriminatory action taken against Mrs. Linsky. So, for example, they shouldn't have put her on the formal performance management process. And as we can see from the compensation on the slide, if we get these things wrong, it can be costly. And part of this case as well, there was an element of aggravated damages because Direct Line did not accept that Mrs. Linsky had a disability. They were unaccepting that the symptoms of menopause could amount to a disability until quite late on in the litigation, which wasn't helpful in the end to Direct Line. So what we need to take from this is it's not that you can't performance manage people that have a disability, but we need to make sure we're well informed by taking the necessary medical advice that we need to make sure that we're thinking, what is the legitimate aim here? What do we need to get from this? Are there any less discriminatory actions we can take? And we shouldn't be asking employees to achieve standards that they're not going to be able to reach because of their disability. And also from this case, just to bear in mind, we must be taking proactive steps to support people with the menopause. So just moving over now to Nick on managing sickness absence.
Thanks, Rebecca. So disabled employees may need time off for reasons related to their disability. I mean, that's quite obvious, but they might be too ill to work, or they might need time off to attend medical appointments. So how do you manage this? Well, the starting point is always to follow your sickness absence policy, and whatever the wording in that policy is. But you should bear in mind that reasonable adjustments may need to be made for that policy. So if your organization uses sickness absence triggers or a trigger point system, and an employee is off with disability related absence, you may need to consider adjusting your policy to perhaps increase the number of absences that will trigger a review, or to record disability absence separately to other sickness absence. So yeah, most of the time you should be able to support your employees and manage their absence, but sometimes hard decisions need to be made, and the tribunals will recognise that. So particularly where sort of you have absence levels which are unsustainable for a particular employee, or where the employee is no longer able to do their job because of their disability. In those cases, tribunals recognise that dismissal may be able to be justified as a proportionate means of achieving a legitimate aim. But it is very fact dependent, and you should always obtain legal and medical advice where appropriate. And that's principally because of what Becky was alluding to earlier around a Section 15 claim. So this is a very common claim that we see is, an organization dismisses an employee for their ill health absence, and the absence is caused wholly or partially by their disability. And yes, sort of from the discrimination arising in consequences of a disability claim, we're looking there at the absence as the cause of the dismissal, and that absence arises as a consequence of the disability. So it's not hard to see how those claims may be made out. So whilst every situation is different, and you should always consider the specific circumstances of your organization and the employee involved, generally in terms of your capability procedure, you should take the steps there on the slide. So consulting with the employee, obtaining up-to-date medical advice where appropriate, considering if the employee is disabled, their prognosis, their risk profile, based on that medical advice, and then considering sort of reasonable adjustments and whether a return to work is foreseeable with any such adjustments, considering alternatives to help them return to work. Can you sort of implement phased returns, reduce duties for that individual? And then, if not, then can we consider any alternatives to dismissal, such as redeployment? And finally, considering sort of the availability of income protection, permanent health insurance, and noting that if an employee is dismissed where they could have benefited from those schemes, then that would open you up to a breach of contract claim. So it's important to be aware of all of those things. So there was another recent employment appeal tribunal case which illustrates these difficult situations and dismissal for long-term absence cases. So that was the case of McAllister and HMRC. Mr. McAllister suffered from anxiety and depression. He was off work for long periods of time. As you can see there from the slide, he was absent for 245 days on 23 different occasions, quite a lot of absence, and was absent for 7 months and unfit to return in any capacity as at the date of his dismissal. HMRC concluded that they'd exhausted all reasonable adjustments, and they ultimately dismissed him at the end of 2018. He claimed that his dismissal was discriminatory, as he was dismissed because of his high sickness absence, which related to his disability. In the Employment Appeal Tribunal's judgment, they said that the dismissal was not discriminatory in this case. It could be objectively justified. HMRC had a legitimate aim of ensuring staff had satisfactory attendance, and dismissal was a proportionate means of achieving that legitimate aim. The evidence in the case showed that there was a real adverse impact on HMRC's resources caused by Mr. McAllister's absence, including time management and staff morale issues. So dismissal was deemed proportionate. And I guess that's probably a key takeaway is having that contemporaneous evidence, be that in documentary or witness evidence, to help with any such proportionality assessment in your cases going forward. I think I'll hand over to Rebecca again to deal with misconduct.
Thanks, Nick. So dealing with misconduct when you've got somebody who's got a disability or a potential disability, we're back to thinking about it's got the similar themes to the performance management route as well, because what we need to be thinking of, if somebody's done something wrong and you need to take them down the conduct route, is it possible that that misconduct has arisen because of something to do with their disability? Because if it is, and we take that action against them, then any disciplinary action, warnings, or subsequent dismissal could, of course, be discriminatory, because it could have arisen in consequence of that disability. And what I'm going to be looking at in a minute on one of the cases is that what transpired from the case we're going to look at is that there's no immediate, it doesn't have to be that immediate causative link that's absolutely obvious to you, and you don't have to be aware of it at the time of dismissing somebody, not to fall foul of a discriminatory dismissal. So we mustn't assume things again. As I've said, it's always best to explore, first and foremost, explore with the individual during that process, if it does go straight into a conduct process, as to why they've behaved in a particular way. Are there any external factors related to health or disability that could have had an impact here? Because ultimately, it doesn't mean we can't take actions. Likewise, mirroring also with the performance management, of course, we can do that, but we have to be thinking about our objective justification arguments. So let's just have a look at a real life example. So this is the case of the City of York Council and Grosset. It's a 2018 case now, which seems actually quite a long while away, but it's the key principles that came out of that still stand good, and I think it was quite a sort of a surprising case at the time. So you may be aware of the facts, but Mr. Grosset worked in the school as an English teacher. He had cystic fibrosis, and he had to go through this regime every day to help clear his lungs, to help keep on top of his condition. And he had some adjustments to allow him to do that. But then there was a change of staff at the school, and new procedures came in. They started putting much more pressure on Mr. Grosset to perform in a different way, and that started putting him under stress and under pressure. And ultimately, what he ended up doing was showing the film Halloween, which is an 18-rated film, to a group of 15 and 16-year-old students. And he did that over the course of 2 lessons as well. So it wasn't sort of just a one-off that occurred. That resulted in his suspension and his dismissal. And Mr. Grosset brought a claim for unfair dismissal and discrimination. That was on the basis of reasonable adjustment and the Section 15 discrimination arising in consequence of disability claim. And that's what we want to focus on, because the point that came out of this case was that at the point they dismissed Mr. Grosset, although they knew he'd had problems with his health and they knew he'd been suffering, they didn't see that causative link between him getting more stressed, his condition becoming worse because of how things had played out, and him having that lapse of concentration. The council were not convinced he had a momentary lapse of concentration, and that's why they decided to proceed to dismiss him. Now, in terms of the unfair dismissal claim, the unfair dismissal arguments were not upheld because we've got a different test for the unfair dismissal laws. But in terms of the actual dismissal, was it discriminatory? We have to look, well, has it arisen because of something arising in consequence of his disability? Well, by the time of the tribunal, there was medical evidence to show that causative link, and the tribunal took that into account. So therefore, you don't need to know it at the time. But I think what we need to take away from that is that if you've got somebody in this situation, the best thing you can do is to get good medical advice, because you need to be as informed as possible as to what next steps you want to take. Because if we need to objectively justify why we've taken an action, and often the objective justification point gets overlooked actually, you need to be thinking, right, there is a link here. Have we done what we can do for Mr. Grosset? Because part of the criticism in this case as well, and this particular element didn't really get tested at the higher courts, the ET made some comments that actually had the school made reasonable adjustments for Mr. Grosset, he probably never would have made this error in the first place. So it's key. If you fail to make reasonable adjustments, or the adjustments that you need to make on a reasonable basis, it can be very difficult then to make that objective justification argument when you're trying to defend a Section 15 claim. And we obviously see Section 15 claims pleaded regularly because, likewise, going back to the performance management as well, if something happens to somebody that they deem to be unfavourable and there's that link, then it can, of course, be on the face of it a discriminatory act. And then we have to be looking into the arena of the objective justification. And that's why it's really important to be keeping records and asking the right questions. So just moving on to the next slide, Nick, as well. So what are we going to do if there is a link? It doesn't mean, as I said before, it doesn't mean we can't take action against employees. It doesn't mean if you've got a performance issue, you can't try and carefully performance manage somebody. It might be that you don't put them into a formal performance situation. If you've got a misconduct situation, it doesn't mean that you can't take them down the misconduct route. But we need to be speaking to the employee and really understanding what's triggering that misconduct. And are we taking appropriate actions? Is there a reasonable adjustment? There might not be, but we do need to turn our mind to it. Make sure we've sought medical advice. We can't make assumptions. We have to deal with things sensitively. And it might be that actually informal management of misconduct is more appropriate if that's the case. It might be that something has happened that's just so serious, it's gross misconduct, and you can't risk that happening again, or you don't believe even if adjustments are put into place, it would make a difference. But as it says there on the slide, if misconduct does persist after adjustment, then of course, we're back into the arena of saying, well, actually, we will now have to implement the disciplinary policy. We're satisfied, we've taken the appropriate steps, we've dotted the I's, we've crossed the T's. If somebody raises a grievance during a process such as misconduct, which is often the case because they don't feel that they're rightly being taken through the process and they want to raise issues with that, obviously deal with it sensitively, deal with it in accordance with your policies. Often that can run in conjunction. Often a grievance is actually their defence to the misconduct points. So it can all be wrapped up in the round, providing people have had an opportunity to put their side across and have their fair say. And also it's really important that we do keep careful records. So collate evidence of the impact of misconduct. I mean, I often see cases where somebody has a disability. That disability may cause them to behave in a particular way. That might be impacting on other people, other members of staff, your clients, or otherwise. And by keeping that careful record, it puts us into a better position if you do need to take action, which they might then later claim, hang on, that's unfavourable treatment against me and I've got a Section 15 claim. But it will put you in a much stronger position to help defend that claim and say, actually, there's a legitimate aim here, and the steps we've taken is a proportionate means of achieving that legitimate aim. So I think that actually takes us to the end of our slide deck as to what Nick and I actually wanted to cover today. So what we'll do is we'll have a look at some questions now and hopefully be able to answer a few of those for you. Just before people do go as well, we have got another one of these webinars coming up on the 30th of April, which is on the recent changes in the law and the Higgs case as well. That'll be my colleagues Alex and Laura. So do look out for that on the 30th of April. So Nick, have you had a chance to have a look at some of the questions and we'll start picking up those?
Yes, looking at some of them. So I had a question in relation to one of my slides on recruitment, and that was so where questions are prohibited prior to making of the offer, does that mean a conditional offer or full offer? That would be, I suppose, the full job offer itself. So not necessarily the conditional offer. There was quite lengthy questions here, so I'll just have a look through some of the other ones.
Yeah, I've just had a quick look at this one, Nick, as well. This is where an employee is unable to work shifts due to ADHD, and you're upfront at the interview about shift work and obtain medical reports, etc. And they've advised that it would be a day shift as a reasonable adjustment. The employee doesn't wish to take any medication. I mean, whether that would or wouldn't impact their condition, what you need to know is you probably need some more medical advice on that to say, well, if medical interventions were made, would this make a difference? Would it, what's the reason why they can't work the shifts? Is it because they need that sort of continuity because of their condition? This is obviously a reasonable adjustments question, but we need to think back to, depending on the size of your organisation, would that be reasonable in the circumstances? Can you accommodate it? If you can't, you just sort of need to think very, very carefully about that. But ideally, the test is quite high. And depending on your size and resources, it might be that if you could work it, that particular person could do day shifts. And potentially you should be putting that in place for that particular individual. It just needs some careful thought, some dialogue with them. Maybe it's not a hard no. Maybe you could try a trial period to say, well, could you try shifts just to see how you got on? If that didn't work for them, then you could revert back. There's a bit of an employee relations piece there, hopefully, that individual.
Good. Got a couple of questions on adjustments to sickness absence triggers, which I'll sort of deal with in one go. So the question is sort of how can you determine what adjustment to trigger points to implement? Presumably this would need to be on a case-by-case basis. And another question was around speaking to occupational health. Or would you suggest speaking to occupational health to get guidance on sickness absence triggers? So yes, because we're looking at, can reasonable adjustments be made here? We want to be reasonable adjustments in a particular case to adjust the sickness absence triggers for that particular employee. We do need to be thinking about it on a case-by-case basis, and that will mean, consulting with the employee, but also getting occupational health advice around that, and considering that internally, but potentially also legal advice. So yeah, case-by-case basis, very much so for those things.
There's a question here that's caught my eye because it does come up a lot. What if you suspect that an employee has a mental health disability, but every time you reach out, they simply tell you to back off? But now you're getting into the realms of disciplinary behaviour. It can be very, very difficult because, as we know from the test, it's whether you know somebody's got a disability or whether you ought reasonably to know. So if we suspect somebody might have a disability or their behaviours are presenting in a way that you think, hang on, this isn't, this isn't them, they're acting out of character, or it might be that they've always behaved in that way, but it's not. You do have concerns about how their behaviours are manifesting and leading to potential misconduct issues. All we can do is try to be as supportive as we possibly can, encourage them to get to go to occupational health and say, look, you can have almost an informal process and a discussion with them to say, these behaviours don't meet the expectations of the company. This is how we need you to behave. We are concerned. Is there anything causing this? Can we explore it? Because if there is, we want to be able to help you. We're here to support you. It's all the supportive piece. But ultimately, I have had situations where people absolutely not engage. Their behaviours continue to fall short of what you expect. And if it does proceed to a disciplinary and you've done everything you can to try and get that information, you can only make a decision ultimately on what's before you. And if you have to make that decision, yes, that could be ultimately, if it came out later on, unfavourable treatment has it arisen because of something arising in consequence of disability, like the Mr. Grossick claim. But if you'd really carefully documented what you tried to do, you tried to put in place even some sort of formal adjustments, you thought, well, let's try this, even if they don't want to do it, let's try this, see if that makes a difference. And you've got that then objective justification. You've got a legitimate aim in that you need people to behave in a particular way, either for your clients, for other members of staff. And if they can't do that, ultimately, is a disciplinary action and a warning proportionate? Likely yes. Has it escalated to a dismissal? Again, you're going to be in a much stronger position to defend that action if that happens. We've probably got time for another couple of questions. Nick, if you've got another one that you want to pick up.
Yeah,
Got lots of
just
questions in the chat box, which is brilliant.
look through. Um, just trying to sift through, see through any ones that sort of relate to the issues that we've been discussing.
Yeah, there's one here linked to, I'll just pick up this first, Nick, if that's okay, while you
Yeah,
have another
sure.
look, because this is linked again to performance. So when dealing with someone's performance and there is a disability, but again, the level, you don't know the extent of that disability, how much onus is on the member of staff to work with their employer to ensure that reasonable adjustments are put in place to help support them? We've probably covered that off a little bit from the last question. We do need to get that advice. We need to encourage them. I've had people, they've sent people off to occupational health 14 times. They've not been able to get anywhere with it. It can become, almost frustrating and difficult because you want to help the individual, but there will come a point where you almost need to say, look, let's give this a go. Let's try this to see if it does make a change. And there is an element of them behaving in a collaborative way with you as well. And ultimately, as I've explained, if you do end up then having to take some action against them, which could be, fall into that unfavourable treatment bracket, you're in a much stronger position to defend the case. And it's not, I don't want people to think, oh, it's got to take months, you've got to drag processes out, because you haven't. It's literally just making sure you're looking at that objective assessment of let's have a look at what's going on here. What else could be going on here? Can we do X, Y, Z to help this individual? What can we put in place? Have we documented it? Have we taken the right advice? And where can we go with it? And also, if it is particularly contentious, do reach out, do take legal advice, because getting it right at the actual dismissing stage or otherwise, you're in a much better position than trying to sort it out later on down the line.
Thanks, Becky. I've got another one here just around an individual not being able to do a fundamental part of their role due to a disability. And would this be a potential capability case if adjustments cannot be made? Yes. So, I mean, it's you're wanting to, as you go through that capability procedure that I was sort of talking about earlier, you're looking to explore every avenue of that if an individual has a disability. So, if you've taken medical advice and adjustments cannot be made, and that's an occupational health advisor has said that, and the individual isn't we're sort of willing to enter into that, then yes, you'd be looking at other options. So redeployment, sort of the other things that we discussed, such as PHI, if in fact there's no chance of them being able to return to work and no adjustments can be made to enable them to return to work, then you would be looking at things like redeployment and potentially even dismissal if that doesn't work. So yeah.
Great. There's just one here I've seen that I just wanted to flag. Can an employer say that because they've put reasonable adjustments in place, they will not discount disability-related absences? Even with reasonable adjustments, part of that reasonable adjustment is likely to give them an additional trigger or an extended trigger to others. So I would just exercise some caution around that, is what I would say.
Excellent.
Just and another question here. Does medical advice have to be sought from a traditional occupational health advisor in the case of neurodiversity, or can we seek advice from a specialist? Well, occupational health are obviously absolutely brilliant. They can give advice. Sometimes advice can come back from OH and be very helpful. Sometimes it is just a regurgitation of what the individual said and it doesn't take you any further. So we either need to ask them, careful questions of occupational health to really understand, or if you can get specialist advice, that's absolutely brilliant. You know, that shows you're opening your mind to what that individual might actually need, and to just be really open to assess fully and make sure you're doing what you need, and it's showing that you are taking, you know, EDI matters seriously, and looking at that individual as an individual.
Thanks, Becky. Yeah, and just saying there's a few questions in here around sending over the slides and whether this is recorded, just to sort of reassure you all this is being recorded and it will go up on our website. So should you ever want to look back at it at any point, you can. And I think it will be shared separately as well. I've got a question around, so what if reasonable adjustments or risk assessments, sorry, restrict you to being able to implement any reasonable adjustments? It's I suppose in those cases you're that would feed into any assessment of whether an adjustment is reasonable to implement in a particular case. Again, it would depend upon what the sort of the risk assessment says or what the particular risk is, but it may be that, you know, it would cause so much disruption to your organization that whatever the adjustment is to cater for this individual, that it wouldn't be reasonable for you to implement it at a particular time. But it's very much a case by case basis, as with anything for sort of reasonable adjustments. Good.
Great. Well, I think that probably just about brings us to the end of our time this morning. Thank you so much for joining this webinar. Please do fill in the feedback as you leave, because we will be grateful for that. And it was great to see you all, and we'll look forward to seeing you at the next session.
Thanks very much, everyone. Goodbye.
Thanks, Nick.
Thanks, Rebecca.
Bye.
Bye.